to start us off, I'd like to turn immediately to Suzette to tell us a little bit about some of the big class action cases this term. Class actions was a theme this term. Just to recall a little bit and put it in context, we've seen that over the last several terms, the Roberts Court has issued a lot of cases in a wide variety of legal areas, including pleading standards, standing rules, private rights of action under federal statutes, in which you might say the Supreme Court has done a lot to limit plaintiffs' easy access to civil litigation through threshold doctrines that make it harder to get going in a case, whether you're to be dismissed on a complaint for failing Iqbal Twombly, or to be denied a private right of action to bring your suit at all, to be required to plead facts with greater particularity. This term, it was Rule 23. Is this a new area where the Supreme Court was making threshold law that makes it harder for plaintiffs to bring, in this case, large-scale class actions in Walmart versus Dukes, or in AT&T versus Concepcion to bring consumer class actions in lieu of arbitration?
Absolutely. I think this term, class actions were really hit hard in the consumer and employment discrimination area because of a confluence of those two major cases, the AT&T Mobility versus Concepcion and the Walmart versus Dukes. And so in consumer and employment area, sort of that critical procedural device, the class action, really took a couple of punches. I would say that it's not dead, but it certainly was injured by the term this year. I do think that this case will make it more difficult in employment discrimination cases. Looking at the case, I would sort of be wary to say that across the board, all class actions are going to be
securities,
negative. Right.
Antitrust, may be unaffected.
Right. I mean, it really speaks a lot to the back pay question. It really speaks a lot to what does it take to have this common glue for employment discrimination. So it seems, it does really seem tailored to the facts and to employment discrimination cases in general. Okay. So I do think it's going to be much more difficult for people to proceed with this kind of systemic sort of challenge.
Okay, Chris, if I said that even unreasonable information or unscientific information, in this case there was a fear that the cold remedy led to a loss of a sense of smell, but there was a big discussion at oral argument about what about a connection of a product to Satanism? And it might have an effect on the stock price, but is that something the company has to disclose? And the answer was basically yes, right? That even unreasonable facts might have an effect on the reasonable investor.
And this also connects to Iqbal and Twombly. The court said at the pleading stage, as long as you've alleged some facts that are enough to make your claim plausible, that maybe it's plausible that investors might consider this information significant and that you'd discover more information in discovery, that's right, that you have to disclose that information, and we're just going to ask what reasonable investors would consider to be material, and whether you have plausibly alleged that this information was relevant.
These cases, like the class actions, are all about access to courts, and so more than they like states' rights, and I think even more than various members of the court like corporations, they don't like lawsuits, is my view. I don't think they like litigators. They don't like litigation. And so there's a lot of cases that are about keeping people out of court, and the preemption cases fall in that category, telling people how to read the prior case.
Is it fair to say that the biggest difference between Geyer, which held preemption to apply, and Mazda, which held preemption not to apply, was the litigating position of the United States government? The Solicitor General urged preemption in Geyer and urged against preemption in Mazda, and that's particularly significant to Justice Breyer, the author of both.
Yes, absolutely. Justice Breyer would have ruled the other way had the Solicitor General come in on the other side. But it would have been hard, given the regulatory record, for the government to have said there was preemption, because there's really no basis for it in the Federal Register notices, which is what both decisions are really just quotes from the Federal Register notices. But the government's position is extremely important in all the preemption cases, and unless, as happened in Wyeth, the drug case from a couple of years ago, unless the government's really overreaching, the court is extremely deferential to their position in preemption.
Say that it's important to emphasize that the ruling in the case is very specific to the employment regulation issue that was presented in that case. One, because the court depended on this specific proviso in federal law authorizing licensing laws. And the opinion by Chief Justice Roberts also went into considerable detail explaining how there really was not a conflict between the federal adjudication and the state law because the state purported to rely on federal databases and federal determinations for deciding who's documented and who isn't. So he said, look, what's the big deal? It's just a piggyback scheme on top of the federal scheme, so there really is not a conflict here.
So are we moving into a new era of state freedom to improvise on immigration controls to fill that so-called federal regulatory vacuum we talked about before?
I hope not, but there's certainly the states are enacting lots and lots of laws. There's been a lot of follow-up so-called SB 1070 copycat laws following this, not this Whiting case, but the criminal enforcement type laws. So far, every single one of those have been enjoined at the district court level on the grounds that they are preempted, that these are really getting directly into the regulation of immigration in ways that are completely impermissible, and they don't have a hook within the law to justify them, but we'll see.
Where there's been a surprising trend with an unusual lineup toward originalist enforcement of the right to confront the witnesses against you, which has led to some big victories for criminal defendants in the Crawford line of cases through the Melendez-Diaz case last term. Is the trend on the Sixth Amendment continuing this term? Tell us about Bryant and Bullcoming.
It's interesting. I don't know whether it's going to continue as it's been. So the alliance between Justices Scalia and Thomas and the traditional left wing of the court, Justices Stevens, Souter, and Ginsburg, did lead to Crawford and the Crawford line of cases. Just for those who have forgotten about Confrontation, in 2004, the court held that if documents or statements of witnesses were introduced, the defendant had the right to confront the declarant of those statements if the statement itself was testimonial. In 2011, and Justice Souter has been replaced by Justice Sotomayor and Justice Stevens by Justice Kagan, and we get two Confrontation Clause cases, Michigan versus Bryant and Bullcoming versus New Mexico. I think what becomes clear in both of those is that Justice Sotomayor is emerging as the swing vote, and that she is much more in the kind of pragmatist camp than I think a lot of people had expected her to be. So in the Confrontation Clause area, I think Justice Sotomayor is really turning into the swing vote, and she looks much more pragmatic in her opinions than I think Justice Souter had been, and than I think people had expected her to be.
Spent a lot of time as a state prosecutor.
Yeah, she did. That's
so
right.
It may be a factor. All right, so Sixth Amendment may be going the pragmatic way of the Fourth and Fifth, not the kind of originalist bulwark it's been. Paul, let's go to the First Amendment. And it was a big term for free speech rights. The speakers won all the prominent free speech cases of the term.
What I would say is what's really happened that's made free speech claims so strong in this court is the emergence of Justice Scalia as Justice Kennedy's partner in almost every case as the reliable, strong advocate of free speech rights. Sometimes they're allied with the more liberal members of the court, sometimes they're allied with more conservative members of the court, depending on the kind of speech claim it is. But when you have those two voting consistently, it's very difficult to lose 5 votes. And so, especially as you point out, Chief Justice Roberts is often there as well, although not nearly as reliably, I would say, as Scalia has become. To some extent, this is a solution in search of a problem. Interestingly, Alito and Roberts concurred, even though they were very negative at the oral argument on a vagueness issue. They were quite critical of the broader protection that Scalia's opinion will accord to video games. And then Thomas and Breyer dissented. Thomas on the theory that if you're under 18, you have no First Amendment rights at all, unless your parents have agreed to let you have them. And Breyer, who is emerging, I think, is probably the weakest guy on the First Amendment most consistently on the court, essentially saying, well, you could call it strict scrutiny, You can call it what you want, but I think there's enough bad stuff here, and it's clear enough to me that these games ought to be regulated.
Well, one dissent was from the 17th century, and one was from the 22nd, right? Justice Thomas said, children have no free speech rights because our traditions going back to the 17th century say they're controlled by their parents.
Right.
Justice Breyer said there's a lot of social science evidence that will get into brains and show us that actually we are inured to violence. So they couldn't have been more opposite in method,
Right.
but both
I
dissent.
mean, the bottom line is you have a majority opinion of the Supreme Court which expressly rejects all those dissents and very vituperatively says the First Amendment's going to apply here. There's a lot of problems in society, and these games may be problems, but there are a lot of problems you can't solve through censorship of speech, like, for example, subversive speech and other things. And we're just not going to do this. So Scalia is quite a remarkable opinion. Now, in Sorrell, this agreed to have the information provided to the pharmaceutical companies. They can opt in if they want. So, he didn't see this as a major First Amendment problem. But then his way of handling all these cases is if it's a First Amendment claim, that triggers a kind of practical balancing of interests in which Justice Breyer decides what interests are important and which ones aren't and tells you what he thinks. So
no
that's
special preference for First Amendment values.
It's really nothing that would suggest that you apply the rules in a way that might lead to an outcome that he thinks is unfortunate in terms of a societal outcome. So.
Justice Alito also shows no special reverence for the First Amendment in every case. He was the lone dissenter in Westboro Baptist Church, Snyder versus Phelps. And again, a few terms ago in U.S. versus Stevens, the animal fighting video case that said he is willing to see new areas of unprotected speech where social mores
Right.
are being protected.
On
So
the other
it was
hand,
quite
he's extremely
impressive.
strong adherent. Justice Alito is very strong on the First Amendment in other areas.
Yes, Doe
Religious
versus Reed.
speech in the Hastings Law School
Hastings
last
versus
term.
Martinez and
Certainly
Doe versus Reed, the lone person who said you have a right not to be disclosed, your identity, a right not to disclose your identity as a petition signer.
The one guy who seems to be in dissent in almost every case, though, is turning out to be Breyer.
Yeah.
Not every case.
No
but certainly
special sympathy for the First Amendment.
Right.
Well, Chris,
What you said does fit in with my other theory, which is that plaintiffs win, and usually not in really close cases, by really close votes, when what the court is presented with seems like a narrow textual argument. For instance, Chris said that Halliburton was a very narrow decision. Plaintiffs won. And I think Williamson was seen by the court as a narrow, let's look very specifically at these Federal Register notices sort of decision. The plaintiffs win. So they can win these textual things. The court's comfortable with that.
Right.
Give them some wiggle room.
Then then you start seeing differences.
And I would add, I think the reason why you see retaliation emerging is something the courts have favored is in part because they're individual cases and that people have real stories to tell. The conservative members of the court are much less skeptical that this is really a lawyer-driven, big cash-in kind of class action thing. And that's what they're most suspicious of is the plaintiff's bar. And so you see these very aggressive moves against class actions in the employment discrimination area. A long record now of cutting back on potential defendants in the securities area, and of course the pleadings and other procedural aspects of it. But I think there is a majority of the court that thinks that the plaintiff's bar is ginning up big cases that don't really have a lot of merit or that the defendants shouldn't have to deal with.
so contingency fee, product liability cases and class actions may lose, whereas individual claims like the fiance, the guy who's allowed to complain when his fiance is fired. Right, so.
Right.
And
This is somewhat of a surprise, particularly given what happened in a lot of the other class actions. And I think part of it was kind of the visceral appeal of, Justice Kennedy included in his opinion pictures of where these prisoners were being held when they couldn't get medical care, and they were held in these little things that looked like old phone booths used to look, and they were locked in there. Prisoners with serious mental illnesses were locked in there, and I think that really affected Justice Kennedy and may well have led to his vote.
And it was a little bit of the dignitary Justice Kennedy, the shades of the Justice Kennedy we saw in Paul's magnificent win in Lawrence versus Texas, or in Romer, where he talks about aspects of human personality that should be protected by constitutional rights.
That's exactly right.
Yeah, but interesting, in the war and terror cases, the Guantanamo cases put constraints on the executive branch, but no individual, not Iqbal, not Al-Kid, and not the humanitarian law project have been able to succeed in war and terror-based claims, and the state secret privilege has kept a lot of other cases from going up. So no major individual victories against executive improvisation in the wake of 9/11. All right, it's time to open it.
Paul, what took so long on the violent video games case? And what do you think of the theory that the Scalia opinion was quite terse, the Alito opinion fairly substantial? Is that consistent with the view that the chief assigned it to Alito in the hopes that it would go off on vagueness?
Well, now that you've answered your own question, Adam, no, that is my theory, that basically Roberts and Alito decided to vote our way, even though I think in their hearts they might have voted against us, to keep it narrow, and write just on vagueness and actually suggest maybe ways that you could go about regulating these materials. And Justice Scalia at some point led the insurgency to get 5 votes to take over the case and write the much broader strict scrutiny opinion. That would seem like the most logical explanation.
It wasn't that Breyer needed time to write the 22-page appendix with
Well,
all the social science?
He had the Supreme Court library do all that work.
There we go.